In this module, we're going to talk about alternative dispute resolutions, and we will talk first about mediation. Let's talk about why we should mediate. There are multiple options for resolving disputes, including dispute mediation, which will be our focus for the lecture series in this module, but there's also other things that we can do to create a constructive venue for addressing conflicts, especially for people who cannot resolve an issue on their own. So again, we're going to focus on dispute mediation, and this is one option that involves a neutral third party, which is the mediator, of course. This is typically used because disputants, again, could not resolve an issue on their own. Mediation has really been around for a long time, but it's very common in labor management disputes, family disputes, neighborhood disagreements, landlord-tenant controversies, environmental issues, crimes, and schools. And in my opinion, and research would back me up on this, that several studies have found that once people agree to mediate a dispute, both parties can reach a solution that they agree upon 80% of the time. So my opinion is that this is an extremely positive approach to managing conflict in a very difficult situation. So 80% of the time, this can be something that is satisfying for both parties, and we'll unpack that a little bit. So let's talk first about what mediation is. We're going to look here at an overview from mediate.com about the generals of mediation.
Mediation is the best way of resolving many kinds of disputes. Compared with traditional litigation, mediation can produce superior and lasting solutions for much less cost in time, money, and emotional stress. Mediation is being used to resolve disputes in business, the workplace, education, healthcare, family, international conflicts, and in cases pending at all levels of the legal system. Some mediations involve only the mediator and the parties. Others can include legal representation. The process involves confidential conversations and negotiations assisted by a skilled, impartial mediator. The flexibility and direct nature of mediation allows focus on the core issues of a dispute and takes into account the unique personalities, needs, and interests of the parties and their representatives. It can thus develop understanding and closure on sensitive issues. In mediation, the parties retain control of the outcome, not a judge or jury. Many issues can be addressed and resolved before they escalate into more serious problems or long, costly legal actions. In many cases, agreements may be achieved in a few hours. Even complex, litigated, or policy matters involving multiple parties, attorneys, and others can be resolved within days. The choice of a mediator for a particular case is important. Mediators' styles, knowledge, and approach can differ greatly. If you'd like to become a mediator or are interested in mediation services, please contact us.
So mediation is a process involving two or more parties who are in conflict with each other and an uninvolved third party, which again is the mediator. The mediator is a neutral, impartial guide who does not have a relationship with either party. And another way to look at this neutrality is something called multipartiality. It's another term, again, discussed here by a mediator on mediation.com, which is really a wonderful resource if you're more interested in this topic.
And I think that we often get confused of what neutrality and impartiality is as mediators. I think that the term that is becoming, I think, more popular, is actually a good one, is multi-partial. In other words, we're not removed. We are partial toward all parties trying to get their interests met. But within the context of multi-partiality, there are also broader principles of fairness, reasonableness, that mediators have to be somewhat comfortable with, as well as the parties, or else it's very hard to get fair agreements.
How are you multi-partial?
Well,
the guy that's beaten his wife.
Well, I probably would not be multi-partial in that I say, well, it's your right to beat your spouse. What I would say is that I think that in a relationship, as a general principle, people don't want to be in relationships where they're harmed. And I can't help you reach an agreement which would essentially foster a relationship which continues harm. If you need to have someone else work with you on those issues, it's not me. Because that's a basic premise. And I would assume maybe you assume that's a premise that you'd follow too. So I think that would probably be an example. Another one would be, imagine you have a company and it's in a developing world, and the company is taking significant advantage of local people for some reason, and this happens all the time. A company is, say, an extractive industry is going to come in, they want to buy land, and they buy land at essentially the local value of land. But the minerals that they're going to take out will be much, much more expensive. So the question is, and this is a dilemma for a mediator, if a mediator is working on those issues, do you operate according to, say, normal standards, or because there's going to be a great advantage gained of this out of, getting the land? Do you say that there should be some different kind of reciprocity? And we can't make that decision, but we can raise the issue about whether there should be reciprocity. For example, should there be a community development fund? That maybe it's not that the individual gets a certain amount of money, but that the community as a whole benefits significantly from that kind of development activity.
So as you'll see from that clip, the mediator serves as a facilitator, not a judge, but they do control the communication process within the mediation interaction. Mediation differs, though, from arbitration and adjudication because the decision-making process lies within the people, not in the court. Let's talk about some principles of mediation. First, we need to understand that mediation is a dispute management process that attempts to promote self-determination. If you recall from Module 4, we were discussing the idea of agentic communication, or self-determination in the context of stress management. That's a similar concept here. Mediation is trying to promote agency within individuals, helping them to make their own decisions and to determine the course of their own lives. Within this, disputants will make informed decisions, both about their own participation in the mediation and about their commitments to proposed solutions. Within this, of course, though, confidentiality becomes central. It becomes absolutely crucial. That if you expect somebody to commit to these things, you have to know that they have to know, the disputants need to be able to understand fully that what they're saying is not going to be taken outside of the dispute by any party. The goals of mediation are potentially broad. They can be controversial as well. Some people believe that a resolution is the primary goal, making emotional or relational issues secondary. We think that humans are rational beings and therefore need to logically resolve the dispute. So for that type of goal, it's strictly just to resolve the conflict and move on. Others believe that emotional issues should be at the forefront, with resolution as a secondary focus. Mediation is seen in that context as a therapeutic event, often an approach taken for divorce or child custody situations. And the final group falls in the middle, believing that feelings cannot be separated from the conflict and thus must to some extent be addressed. The bottom line here is that the mediator brings with them an ideology regarding the goal of the mediation, and that will influence the methods and goals that the mediator uses. So when do we use mediation? We would use mediation when you want to lower costs, when you want to have a relatively speedy management process, when you want to engage in a process that is